I would like to welcome everybody on behalf of the Institute of International Shipping and Trade Law to this webinar. Of course, this event is the product of the COVID-19 pandemic, but as you appreciate, not all the consequences of this crisis have been as positive as this one. Several legal issues emerging with regard to contracts, particularly commercial and maritime contracts, and that's exactly what we would like to do today. We would like to elaborate the kind of impact of the crisis on the performance of different types of commercial maritime contracts. The person who will start us going is Professor Tettenborn. Professor Tettenborn will talk about the impact of COVID on the sail contracts, particularly from the international trade perspective. Then Professor Simon Bowen will take the floor and take us through the charter parties. Obviously, there is a connection between charter party contracts and trade contracts. Charter parties usually being the transport arm of the sail contracts. And he will look at the issues concerning COVID and the performance of charter parties, impact onto the charterers' obligations, onto the ship owners' obligations. And last but not least, Professor Loludas will take us through the air law. Most of us cannot fly much nowadays, but he will certainly help us to fly a bit. He will look at the carriage of carriage contracts by air, the impact of COVID on them. And I think he will also say a few words about the passenger issues concerning the crisis. The plan is in the first 1 hour, we're gonna take the presentations one after the other in the order I indicated. And hopefully that will give us 15-20 minutes at the end for questions. For your questions, you can write your questions on the Q&A session, and obviously I will then direct them to the relevant person. If they are easy, I will answer myself. If they are difficult, I will definitely pass it to Professor Bowen, Tettenborn, and Professor Loludas. So without further ado, Professor Tettenborn, do you want to start us with the sail contracts?
Right. I hope you can all hear me. What I've been given is the widest and the vaguest of all the topics, which is how far COVID might affect trade contracts and sail contracts generally. This, of course, runs through the whole gamut of contracts of this sort, starting from agreements to deliver merchandise to Marks and Spencer's, agreements to truck fruit from Spain to Britain, or for that matter, agreements to carry out some major construction project, be it in Bulgaria, be it in China, or whatever. So what I say is obviously going to be fairly vague, fairly general. I'm going to split it into 3 parts, and you can see that on the slide. I'm going to start briefly with the common law doctrine of frustration. I'll then go on to illegality, which actually needs a certain amount of separate treatment. And after that, I'll go to what might in practice be the most important of all these topics. That is actual contract terms, force majeure contract terms dealing with unexpected events. So it'll be frustration, then illegality, and then force majeure. Now, I'll begin with frustration, and Barish quite rightly has taken the hint and put us across. One brief note to start with. Some of you will be civil lawyers. Let me just say one thing about the way we do things in England, which leaves civil lawyers saying they'll never understand the English. In English law, by way of background, there is no general exception in respect of force majeure when it comes to contractual liability. What we do have is a doctrine called frustration, which essentially says that if a contract becomes impossible or virtually impossible to perform, the whole contract disappears. And I want to say something briefly about that. I've started with the definition of frustration. Previous slide, please. Which is very well known to English lawyers. Apologies for teaching my grandmother to suck eggs. Frustration occurs that whenever, without either party's default, performance becomes impossible or completely different. It then goes on to that Latin phrase, non haec in foedera veni, this isn't what I signed up to. Now, the important point is that, next slide, please. That's better. Frustration is actually very narrowly construed. It only applies to impossibility or something very close to impossibility. And it equally doesn't apply where a particular event is at the risk of one party. Now, in practice, that means that when you're dealing with contracts of sale, it's most unlikely that the doctrine of frustration will apply. And I've given the three reasons there. The fact, if you've got a contract of sale, the fact that the seller can't get supplies for love nor money will not frustrate the contract. You can simply forget about it in those circumstances. Similarly, under C, the fact that all the truckers happen to be delivering something else, and that therefore it's going to be very difficult to get the stuff to the buyer. Again, in practice, don't bother with frustration. And thirdly, what's down here under B, the fact that the buyer can't use the goods. For example, if you've got a contract by a retailer to buy perishable goods, the fact that the retailer has been shut down and isn't allowed to sell them to the general public, so those perishable goods are simply going to perish in its warehouse, well, sorry, that's just tough. So in practice, I think you can put frustration on one side. It's very much of an annoyance for law professors who absolutely love frustration, but in practice, lawyers can forget about it. Turning to illegality, which I'm actually going to regard as separate from frustration. This at first sight looks slightly more hopeful if you're thinking of trying to get out of a trade contract, though for reasons I'll come to, it's a little bit more helpful, but not that much. But anyway, illegality obviously is potentially applicable because the result of COVID, and in particular, the result of the COVID lockdown, is that it became illegal to do a great many things. Having said that, however, certainly as regards English law, and I'm going to have to be pompous here and say, as they do at the bar, I am not qualified to advise as to the law of France, Germany, Bulgaria, or Taiwan. But as regards English law, actually very little of the illegality affected purely commercial operations. Most of the restrictions were on citizens like you or me. You can't go out, you can't go into the park, you can't meet your friends, you can't go and get your hair cut, etc. The delivery of goods or services was actually very much left untouched, because obviously if I agree to deliver goods to you, that is a job which I can't do from home. So it's work which I have to do at my place of work. And it, generally speaking, was left untouched by the lockdown regulation. So in most cases where you've got a contract to truck a load of peaches from southern Spain to Britain, or to take out construction materials, to truck out construction materials from Britain to some power station project in Varna in Bulgaria or something like that, it's unlikely that illegality is going to affect matters. Right. Now, so one or two points actually where it might be relevant. Now, the first of them, and Barish has quite rightly anticipated me and seen this is the next slide. Export and import bans. Now, obviously, COVID regulations vary enormously between different jurisdictions, and in certain cases, they might actually involve the closing of borders, the prevention of traffic, not only in people, but also in certain kinds of goods across those borders. Unlikely, but certainly possible. Now, two restrictions, export restrictions, they are unlikely, except perhaps, speaking slightly cynically, for PPE equipment and things that are regarded as very valuable for one particular country. Export restrictions saying it's illegal to take something out of a particular country. Obviously, if I agree to carry goods from Spain to England and it becomes illegal to remove those goods from Spain, obviously that is going to get me off the hook. I can't be guilty of breach of contract. But export restrictions aren't likely to be that common. Import restrictions, and of course this is likely to be most common, because if you're dealing with the effect of a pandemic, you're likely to want to prevent quite a lot of things coming into a jurisdiction. What's the effect of import restrictions? The answer normally is not very much on contractual obligations. The reason being this, that in the case of nearly all international sale contracts, the import of the goods is entirely a matter for the buyer. In just about all the Incoterms styles of contract, except perhaps for DDP, don't ask. If anyone really needs to know, I'll tell them afterwards after class. But in just about all the other international sale contracts, the seller's job is essentially to put the goods on board the truck or to hand the goods over to the trucker. Once he's done that, he's entitled to sit back and wash his hands, a bit like Pontius Pilate, and say to the buyer, right, you're on your own. I've done my job. You take the risk that you won't be able to import the goods into your own jurisdiction. So it's unlikely in practice that import restrictions are going to have a great deal of effect. If I could turn to the next slide, please, because I'm obviously aware of the time. Foreign law and illegality. One thing you do have to note is that when you're talking about a trade contract, an international sale contract, the law of the other country may be relevant in certain cases. And I'll give you a couple of examples. Imagine that you've agreed to do construction work in a foreign country. I'm tired of Bulgaria, so I'll say that it's Saudi Arabia. And because of COVID, Saudi law now says that the construction site can't be worked on. In that case, actually, even if the contract is governed by English law, it is likely to be put to an end by illegality, because, of course, an English court will not enforce an obligation. It won't award damages where performance of the contract would have been illegal by the law of the country where the contract was to be performed. Similarly, if I agree to import goods into Britain from some foreign country, and for some reason it becomes illegal for me to collect those goods from the warehouse or wherever the goods originally are, again, the same principle applies. English law won't enforce a contract to do an act in a particular country which is illegal by the law of that country. So that means that if you are in an international transaction, it may be necessary actually to get on the phone to a lawyer in that country and say, right, can you actually tell me precisely what became illegal in your country as a result of COVID, so that I can see whether in fact this contract ceased to be binding. Okay, now I want to turn now to the third of these topics, which is actual force majeure clauses. Any properly drafted international sale contract will have some sort of clause dealing with events beyond the control of either party. It's very difficult to advise generally on these clauses because obviously it depends on the particular contract concerned. Force majeure clauses vary from immensely complicated ones taking up something like a side of A4, which you find in oil and gas sales contracts, to simple sort of two-liners, which you find in quite a lot of bespoke sale contracts. Neither party shall be liable for events beyond his reasonable control. So, there's no such thing as a general force majeure clause, but there are nevertheless one or two general principles that you need to bear in mind. One, if you want to use a force majeure clause to let you off the hook, you've got to get your act together, and in particular to get your evidence together. The burden of proof is on you. It's entirely on you. You've actually got to prove the events concerned and show that the clause applies. Secondly, and this is point 2 on the slide in front of you, it's not enough to show that an event has occurred which amounts to force majeure. You've got to show causation, at least in the vast majority of cases. You've got to show causation. You've got to show not only that the event took place, but that it actually stopped you performing. And I've given a couple of examples there. I won't read them out. You can see, I think, the point that I'm trying to make. So you've got to show not only that you've got a force majeure event, you've also got to show that it did actually stop you performing. And I gave those 2 examples, as I say. The guy who agrees to manufacture to the buyer's order and then finds that he can't use his factory, that's okay. But if people could have fulfilled the order and done the paperwork working at home, then even though COVID was in the background, nevertheless, you're likely to continue to be bound. Can I ask for the next slide, please, Barish? Oh, that's right. The other point to make is that not only have you got to show force majeure and got to show causation, generally speaking, courts do not construe force majeure clauses as protecting you if the screw up was your fault. And they're likely to put quite a heavy burden on you to show that. So I gave you some examples there. Your entire workforce is isolated, so you can't provide the goods or services concerned. Okay, that might very well be force majeure preventing you performing, but nevertheless, you've got to get your act together and have some sort of evidence that it wasn't your fault and that you took all reasonable care and you didn't yourself negligently expose your workforce and therefore cause your premises to be closed down. So you can see what I'm getting at. You've got to show it wasn't your fault and you've got to be ready with the evidence concerned. I think I've done that on 19 minutes, and there you have the sign for the coffee break. Thank you very much indeed, ladies and gentlemen.
Thank you very much. Actually, everybody can have their coffee at home as they wish. We will proceed with Simon. Thank you, Andrew. Simon.
Right, okay, Barish, if you could get me on to my first slide. I'm going to question 1. Yeah, I'm going to be talking about how has COVID affected your charter parties. I'm going to be looking at voyage and time charters. I'm not going to be looking at demise charters, and I'm going to assume that these contracts are subject to English law because that's all I know about. So, or should I say English and Welsh law, if I'm going to be correct. So they're going to be 10 questions, and that gives me about 2 minutes per question. I hope I can rattle through them. Question 1, does it frustrate my contract? Well, you need something pretty serious to, an external event pretty serious to frustrate your contract. And COVID has not been that in the context of carriage of goods. It's been pretty damn serious. No, not yet. I'll say next for you, Barish, when it comes up. It's been pretty damn serious for us citizens sitting inside our houses and wondering how far we can walk our dogs and can we go and shop more than once a day. but trade has gone on. There have been delays, and that's really what I'm going to be looking at, is how are these delays going to pan out in the context of voyage charters and time charters. And the main delays are going to be, first of all, getting your free pratique. It's no longer going to be a mere formality. This is a serious thing. Secondly, quarantine. You may be routinely quarantined just because you've come from a particular country. Your ship may have to wait 14 days, irrespective of whether there is any actual evidence that the crew have got COVID. Or you may get quarantined after you've had your free pratique, and you find that actually one of the crew has got COVID. And there have been recent incidents of this, particularly in South Korea, where a ship with a Russian captain and his crew, I think 19 of them were tested positive for COVID, and I think that ship is still under quarantine. So I don't think these delays are enough. So on with the next slide. Thank you, Barish. You read my mind. Now, the next question is, this is something which I think only really was an issue in January. January, early February, if you looked around the websites, the big thing was unsafe port. And you may well have been in the lucky position of having an owner ring you up and say, I've been ordered to go and load in China. Can I refuse to go there because it's going to be an unsafe port? It's the type of question people got asked about with the Ebola crisis in 2014. I remember getting asked a similar question back in, I think, March 1980, when there was a ship about to go into the Persian Gulf. And if this is the day after Carter's failed rescue mission for the American hostages. And, is World War III about to break out in the Persian Gulf? I said, well, yeah, wait and see. But at the moment, I don't think you can refuse to carry on to your ports in the Persian Gulf. And, as it was, I was proved correct. But now, unsafe ports. Here's the classic definition. Port will not be safe unless in the relevant period of time the particular ship can reach it, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. Well, the ship itself physically isn't going to get hurt by going to a COVID port. The crew might be at risk, although there's a question of whether safety to crew comes within this definition of safety. I would say that it does, but probably with the precautions which were being taken in Chinese ports, you could say that there actually isn't a danger to the crew. The big danger which you might be worried about, which didn't materialize, is whether if you go into a Chinese port in mid-January, end of January, are you going to get blacklisted when you want to go to other ports? That didn't happen, but it might have happened. And so I'm very glad I didn't have to answer this question towards the end of January 2020. I would have said, wait and see. But anyway, not really an issue now. We've all got COVID. Well, not us individually, but every port in the world is subject to it, and there are different restrictions depending on which ports. Now, question 2, my ship. Unsafety about ports. Yes, a few extra things. Just because there's going to be delay doesn't mean the port is unsafe. Effectively, the delay has got to be so long that it frustrates the contract. That's the Hermione. A pointer to the fact that the question of safety may extend further than just the physical ship itself is Champa and British India Company, where a ship on her previous voyage had been at a plague port, Mombasa. And because of that, on her next voyage, she has to get her cargo of lemons fumigated. And that then is not very good news for the lemons. And that's regarded as being an unseaworthy ship. So that's something, you know, that is something which I think could be used to expand the scope of safety as regards ports. And remember, of course, that there's the duty to renominate. The port is safe when you nominate. Circumstances change, it becomes unsafe. You, as a charter, have the duty to renominate. Right, onwards. Question three now. I've gone a bit too far, but this question about nomination of ports and safe ports, this is not a voyage charter thing. It's more likely that with your voyage charter, you've got definitely nominated ports. You might have safe berth warranties, but that does not import any safe port warranty or any warranty of the approach voyages, the approach to the ports being safe. And there's a couple of cases called the APJ Pretty and the Reborn, which establish that. There is, however, a thing called the near clause. You have your discharge port is qualified by the words "or as near as you can safely get." So that means that if there are substantial delays in that port due to things which haven't been foreseen by the parties at the time they negotiated their charter, then you can go and discharge in an alternative port. An example of that is the AFAMAS, where restrictions on navigation in the Mekong River were going to substantially delay the passage of the vessel to the second discharge port in Phnom Penh. These are restrictions due to the outbreak of the Vietnam War. And in that situation, the ship was able to discharge the cargo for the second discharge port at the first discharge port, which is Saigon. But the delays there were quite substantial. And I don't think the delays we've got with the COVID crisis have been substantial. So I think we can forget about that one. Question 4. Can I give notice of readiness under my voyage charter before I obtain free pratique? Now, in happier days, the answer would be, yeah. You know, there's the Delian spirit, the Court of Appeal said, well, you can give NOR before you get free pratique if free pratique is going to be a mere formality. Well, that is not the case in our post-pandemic world. No, you can't give your NOR until you've got your free pratique, and that's going to cause some additional delays, and those are going to fall on owners. Question 5. I've arrived at the load port. I'm not going to get my free pratique for a few days because of this COVID thing. I've got a cancellation date tomorrow. Can charterers cancel my voyage charter? Yeah, tomorrow they can. You haven't got free pratique. You're not ready. That's bad news. Obviously, once COVID started becoming prevalent throughout the world, people presumably reflected that in their new charter parties when they were choosing their cancellation dates. Question 5. Question 6. My ship has been quarantined for 14 days because one of the crew was suspected of suffering from COVID-19. Will laytime run during this time? Well, probably laytime won't have started, because, but you could have the situation where free pratique, you clear free pratique, you give your notice of readiness, and then one of the crew starts reporting the symptoms of COVID. High temperature, hacking cough. You dutifully inform the port authorities, and they come over and say, yeah, test him, yeah, he's got COVID, you're going to have to stay here for another 14 days. Laytime will be interrupted. That, you know, the problem is due to your crew member. It's the fault of the ship owner. You might have an exceptions clause, but its non-actionable fault will interrupt laytime. So it doesn't matter that you've got some sort of exceptions clause for protecting you there. Right. Time charters, and a sort of similar sort of type of issue with quarantines and off hire. Obviously, ship owners don't want your ship to go off hire, and time charterers do. So the ship's been quarantined for 14 days. One of the crew suspected of suffering from COVID-19. Will the ship go off hire for this time? And if so, can charterers claim the value of the bunkers consumed during the time? Now, the answer to the second question is no, because unless it's specifically provided for in the off-hire clause. The only way you're going to get your bunkers consumed during that time is by showing that this delay has been caused by a breach of contract by the ship owner. I'm going to take as my sort of standard off-hire clause the NYPE 1946 clause 15, still one of the most widely used forms. And here we are, loss of time, and there's a series of there's a list of things which will put the vessel off hire. Deficiency of men, well, this is not really deficiency. We've got the right amount of crew, and probably the remaining crew who are not sick can do the work. The trouble is that because of the quarantine, you're not able to get to a situation to do the work. So I don't think that would be deficiency of men. I think it would be under American decisions, but it probably is going to come under this any other cause preventing the full working of the vessel. Now, those causes don't have to be linked to the vessel itself. It can be a cause which relates to the crew. And I think that is something which Mr. Justice Ricks considered in the Laconian Confidence. Now, Obiter said that this any other cause would cover loss of time due to crew sickness. And he pointed to a case called the Apollo, where you've got delays due to the fact that the Port Authority have been informed that 2 of your previous crew disembarked at the previous port with typhus. Now that was off hire. Now the off hire clause there had the magic word whatsoever added. But Mr. Justice Ricks was of the view that it would have been off hire even without that extra word. Right. I think just a few more words about the quarantine before I get onto the Mari H. We can. There may be a difference though between quarantine, which is due to a sick crew member, and quarantine, which is being routinely applied, irrespective of whether your crew is sick or not. And I think that would require you to have, this is nothing to do with the ship itself. This is nothing to do with the crew. This is just, we're being really cautious because of COVID. If you've got the word whatsoever, that would amount to an off-hire period. But if you haven't, I don't think it would do. And the nearest analogy I can give is the Laconian Confidence, where the port authorities, there's nothing wrong with the ship or the crew, but the port authorities unexpectedly say, right, you're not leaving until you've got rid of all the residues and sweepings in your holds. And it took a substantial amount of time for that to be achieved. That was not off hire, but it would have been off hire had the words whatsoever been appended to any other cause. Question 8. Okay, the vessel's gone off hire. Can I recover it back from the charterers by way of the express indemnity or the implied indemnity, which is implied into time charters? Well, there was an interesting case on this called the Mari H. The indemnity is not excluded from matters covered by the Charter Party clauses. And in the Murray H, a portion of the off-hire was recoverable by way of indemnity. And what happened in the Murray H is you've got some of the cargo is explosives. And the Charter Party says the explosives can be loaded, but at charterer's risk. Ship gets into problems in the Bay of Biscay and then has to go to a port of refuge, Lisbon, to restow the cargo. She goes off hire for that period. That period is lengthened because of the difficulty and care you needed to offload the explosive cargo to enable you to do the restowing. And that additional time was recoverable by way of indemnity because it has been caused by the charterer's order to load an explosives cargo. So would that apply with the order to go to a port which turns out to be infected with COVID? And well, there's an argument about that it could be, and I've certainly seen suggestions in various online discussions about this, that this could be the case. I don't think you could recover it by way of indemnity if you've got a situation of quarantine due to the presence of COVID in the crew. I mean, that's plainly the ship owner's fault. But if it's just a general quarantine, it's arguable. But I would suggest that this is actually a risk which the ship owner has undertaken. It's not unheard of for ports to have outbreaks of diseases. It's not unheard of for there to be quarantines due to that. Ebola, SARS, MERS. I mean, we've had this before. But I wonder whether we will get some litigation on this one. Question 9. Barish is moving me along quickly, which is good. I don't want to deviate too much because deviation is the topic of my 9th question. A crew member is seriously ill with COVID-19. Can I deviate to the nearest port to get medical attention for him? Of course you can. Justified deviations to save life. It doesn't have to be life of people in peril on the sea. I mean, it can be the life of your own crew member. And if you've got a clause paramount, you've got Article 4, Rule 4 of the Hague Rules, which allow you to do that. But even if you haven't, it's a justified deviation. But the vessel, I think, will be off hire for the period of the deviation, so bear that in mind. And now, question 10. Barish, can we move on to question 10? Okay, the delays, these COVID delays, these wretched quarantines have meant that my cargo has deteriorated. Am I liable for damage to the bill of lading holder? Well, let's assume that we have some version of the Hague Rules applying to the bill of lading contract. There are a couple of nice looking defences which are going to get you off the hook, you hope. Article 4.2, the arrest or restraint of princes, or the quarantine restrictions. Well, we've had quarantine restrictions. But it could be that you have got delays caused by unseaworthiness. Your crew has come down with COVID. That's meant that you've been quarantined. Well, if the crew have got COVID when they come on the ship, I would suggest that that would actually make the ship unseaworthy. Ah, you say, but what about due diligence? I've got the clause paramount, I've got the Hague Rules, Article 4.1, due diligence. Well, it's a non-delegable duty. I think that it goes all the way down to your servants and contractors, where the crew taking due diligence when they came on board your ship at their last shore leave, obviously now a distant memory for most members of the crew. Have they been taking care when they've gone to dodgy nightclubs? That, again, could be an interesting issue to come up. So I think I've done my bit within 20 minutes, I hope, and I shall bow out now.
I think you've done excellently, Simon, with a bit of a prodding along the way. But
Thank you.
thank you very much. George, without further ado, we move on to you now. Thank you.
Yes, hello. Hi, everyone. And welcome all of you attending our first webinar, or hopefully one of many. We discussed, I think I'm coming at the end, because I think Andrew gave the trade view and breach of contract view. Simon looked into charter parties, and I'll be looking more into contract of carriage by air, but I will be looking mostly on the contract of carriage, not charters, not so much trade issues. Now, aviation probably was hit more than any other transport industry as a result of COVID-19. You all heard the stories about airlines parking their aircraft all over the world. Some of you, or most of you, probably you have vouchers now with all your flights cancelled. But I think unless you are in the industry, you've never realized the importance of air cargo. And I think aviation, opposite to what you see in shipping and probably now in road transportation, cargo is not the guiding force. The passengers, transportation of passengers is the guiding force. Most regulations, the national conventions are guided by the passenger issues. But COVID-19, pandemics like that, brought cargo back into the driving seat of the aviation industry. And it brought back in two respects. First of all, is what the EU has identified at the end of March, that how we're going to move now essential items. The aviation is the only way of doing that, mostly for times of timing and a quick move from place to place. The other part is mostly a private one, a commercial one. Airlines have lost a lot of revenue from the cessation of passenger movements, and they looked at cargo now to replace some of that revenue lost. And although at the beginning in March 2020, the cargo movements were contracted, as I say on the slide, by 15.2%, airlines realized that there's a lot of demand for cargo. There's still a lot of demand for cargo, both related to COVID and not related to COVID. And if you look around, a number of them converted passenger aircraft into freighter aircraft, to be able to carry more cargo. Now, some evidence suggests, for example, that Air China managed to get 20 even more flights from Shanghai to Los Angeles per month, more than their average flight schedule. And also that China Southern has managed to fly its cargo aircraft 15.5 hours per day, which on average at similar times the year before was 10 to 12 hours per day, which demonstrates that now airlines are looking into cargo to get back some income, but also regulators and are looking for airline to deliver what we need in terms of COVID research and in terms of COVID treatment. But that involvement now, and Boris, if I can move to the next slide, please, raises the issue of force majeure, frustration, and so on. And the first question I have to pose is, how relevant is a force majeure clause if you have a claim against an airline for loss, destruction, or damage of your cargo? Now, the simple answer is not very relevant. And I will explain now in the next couple of slides why it is not relevant, why force majeure clauses do not help a claimant against an airline when it comes to the carriage of goods by air. First of all, airlines do have force majeure clauses in the general conditions of carriage. It's regulated by IATA. There's a standard general condition of carriage. Airlines are allowed to insert clauses here and there. But the standard IATA conditions, they don't contain a force majeure clause. The idea is that we cannot find a clause that will satisfy all our members, and that's more than 80% of the airlines around the world. So we'll leave it to them to decide what kind of clause they are going to use. And most of them, if you look around, they have a bit of a let me, because there's a bit of my voice. If I turn off my camera, that might help, I think. So, and most of them would have a rather sophisticated clause. It would be, like Andrew said, almost half a page to one page force majeure clause. And they will refer to events beyond their control. They will refer to weather conditions, but most of them don't refer to quarantine and to pandemic. And the discussion is now whether this type of force majeure clauses will be amended to include quarantine situations and also situations regarding to pandemic specifically. As the advice now that most airlines would get is that you need to refer them specifically if you want to be sure that you'll be able to use them. Now, if there is a claim now against an airline, and Baris, can you please go back to the previous slide? The question is, can I defend this claim on the basis of a force majeure taking place or frustration under English law? The answer is no. And the reason for that is Article 29 of Montreal, which says, and courts have applied thoroughly in cargo cases, that no, you can't bring concepts of domestic law in a claim between a consignor or a consignee and an airline. You have to limit yourself, both as a defendant and as a plaintiff, to what the Montreal Convention provides. And if you don't do that, Article 26 of Montreal comes to bite you, in the sense that if you use a force majeure defense, you're trying to relieve yourself of the liability imposed by Montreal Convention. But can we move into the next slide? So courts in the past, not in pandemic situations, have, especially in cargo claims, have been diligent. They have applied this convention. They wouldn't allow claims under bailment or under contract law or even under tort law if there's a situation. They will stick to the convention. So the next step is, all right, I have a claim related to COVID. Let's say customs were closed down. There are delays. My crew fell ill an hour before the flight. They had to isolate. They have to. I had to cancel flights. What kind of defense can I use from the Montreal Convention? Now, if the claim is for loss, damage, or destruction, not for delay, the only relevant one or potentially applicable is the one I have highlighted in Article 18.2, an act of public authority carried out in connection with the exit, entry, or transit of the cargo. So that would apply if there is a problem with customs. If the customs have delayed the processing of goods, if customs have declined to accept allow import of certain goods, to give priority to others, and the goods are damaged during this waiting period, or they have to be sent back and they are damaged on the way back, potentially the carrier can argue that yes, I tried to import the goods, the customs said no, and that's it. I can't do anything else. But that will not cover a situation where, for example, again, your crew falls ill, you can't find replacement crew quickly, and goods, perishables, vaccines, or blood plasma has issues. Now, where these situations might prove more useful is if the claim is for delay. If the claimant argues that I suffered damage as a result of delay, you move from Article 18.2 to Article 19. And there you can see that there is a very wide, broad defense, that the airline can avoid the claim if it proves that it took all measures, all reasonably necessary measures. And then you start a discussion. My pilot fell ill an hour before. What did you do to replace him or her? Did you look around? You have another crew. If you as an airline, case law so far suggests that yes, I looked around, I tried to bring in a new crew, cabin crew in, but it took time because a number of my employees are in isolation or are in hospital as a result of COVID. Most courts will tell you, yes, you did that you reasonably could do to avoid that damage. What though it's tricky here is that courts, when it comes to passenger delays, and it's exactly the same article that deals both with passenger delays and cargo delays, recently have tried to explain these reasonable measures from a perspective of the regulation, the European regulation on delay of passengers, which requires that your only defense as an airline is that you took extraordinary circumstances. Although it's a very different wording, the convention does not require extraordinary circumstances, it only requires reasonable measures. There is a possibility that even if you try to defend the claim as an airline on the basis I did everything I could, that a court will say, yeah, but the case law under Regulation 261 requires a bit more effort from your point. So for example, you should know that there is COVID issues. You should have taken care to have some pilots on standby to take care of that kind of situations. I believe it's a big mistake, of course, but it has happened and it's happening more and more in terms of passenger delays. And we might see some spillover of that new case law into cargo claims. Boris, can I move to the next one, please? Now, the other impact of the pandemic is that substitutions. It has increased the number of substitutions. So you plan to carry goods by air, but this, due to airport restrictions, customs restrictions, you have to move them by road. Very common practice in Europe, even before COVID-19. The majority of consignments in Europe, there is some anecdotal evidence that are being carried by road, even if you contract with the airline to carry them by air. And why such a extensive practice? Because the standard airway bill enables such substitutions without notifying the consignor. So the airline has the liberty to move things by different modes of transport, unless, of course, the consignor gives instruction as to why he or she wants these goods to be carried only by air, which rarely happens in real life. Now, if you substitute, then you open the whole debate about CMR. And I'm not going to go now in this discussion, but in Europe, there's a bit of a confusion there. There's a bit of divide. English course will tell you if you use a road transportation, even if you have an airway bill covering the road segment, CMR would apply. Germans and Dutch courts will tell you, no, we don't apply CMR there because CMR is not prepared to apply in a multimodal contract under an airway bill. But also, even if you leave out CMR in other parts of the world, you raise the question, which law applies in the road segment? There is a line of American decision which says, like, if you have an airway bill covering the road segment, you apply the Montreal Convention as a result of contractual incorporation. You have other cases in Europe which say, if you actually carry the goods by road, you don't apply Montreal, but if you put them in a warehouse, those same goods during transportation, you would apply Montreal Convention. So again, there is a bit of a discrepancy there as to which law would cover these substituted segments. Boris, next slide, please. I think I will try and finish in 5 to 10 minutes. The good thing, though, from a carrier, if the CMR applies, is Article 17.2. Article 17.2 of CMR has a fantastic defense that I think will be very relevant for pandemic, that liability will not fall on the road carrier or the airline using road services if it was caused by circumstances which the carrier could not avoid and the consequence of which he was unable to prevent. That's better for an airline compared to the Montreal, because remember, if you have lost, damage, or delay in Montreal, your only defense, related defense, is act of public authorities related to the exit or entry. Here you can argue that I was unable to prevent the rerouting of the cargo. I was unable to prevent the non-passing through the customs at a certain time. And English courts have interpreted this provision to mean to look for feasible measures based on, and they judge the feasibility of the measures you took as a carrier based on the nature of the cargo, the value of the cargo, and the route that you have taken. So in that respect, CMR in a pandemic like that allows more flexibility to the carrier to say, look, I'm not going to touch that. I'm not going to pay for that claim. I'm not going to go into this position because I understand we don't have enough time, but if you can go to the next slide, I will touch the next 2 slides. Very quickly, a positive coming out of the discussion about pandemic in aviation, and for those of you who want to look further into that, we have Daniel, Sofin, and I have published or are about to publish an article on how the pandemic might change the industry in a positive way, is that everyone now in aviation is discussing about digitalization, their road supply chain. We were in a good step up even before pandemic. 67% of consignments moving by air are being done on the basis of airway bills, but the pandemic made the industry realize that we need more than airway bills, electronic airway bills. And there are 2 projects that are currently looking closely into that. The first one is the private one, the IATA One Record, where they try to digitalize every single document used in the supply chain, from invoices to custom declarations and so on and so on. And the other one, the public one, is the Federated EU project for digital cooperation in logistics. That federated program started a year before the pandemic, very timely, and essentially tries to create a platform in Europe where all modes of transport will coordinate as to not only documents of transport in the sense airway bills, bills of lading, but also any other documents required to pass through European customs, which is very timely. And I think the idea is that now they will expedite the development as a result of what happened with the pandemic. And before I leave you, I will go into the last slide although it's a bit outside the cargo regime. But I think all of you will fly, who have flown, or we will fly at some point, and in the back of your head, you always have the point, can I claim against an airline if I contract COVID-19 during flight? The answer is maybe yes, maybe not. I would most inclined to say maybe not, and I will explain why it would be a difficult claim against an airline. Now, coming back to what Simon said, we don't look into negligence for airlines. We don't look into duty of care. We don't look into due diligence. The only thing we're looking at is in Article 17 that I have highlighted here. Have you suffered an accident? Is your injury, your death, your injury, the result of an accident? And the accident has been defined to mean an unusual and unexpected event that's external to you. So as a claimant, you would ask, what is this unusual and unexpected event that happened to me? Getting COVID-19 in an aircraft now, is it unusual and unexpected? It's not unusual and unexpected. You can argue to get COVID-19 if you are on the street, if you go to a pub now that things have opened, in a restaurant, if you go to work. So why should it be unusual and unexpected to get COVID-19 on board the aircraft? The counter argument to that is that there have been cases in the past, both in the UK and the US, Court of Appeal cases, which said if a passenger sexually assaults a co-passenger, the airline is to blame. There is an accident because of how the cabins are. It's close proximity between passengers. You can't police them. So we put the risk on the airline. So you might argue, I was sitting next to 3 guys or to 2 guys, one of them had, and proximity. What did you do? You didn't keep social distancing. Of course, there's always a question of how you prove you contracted COVID-19 during flight. There are some arguments that saying that with tracing, you can establish on the balance of probability that you got it during the flight. But even if you go past the causative element of COVID-19 and you prove that, look, there is a problem with the cabin, the other point is, what was the surrounding circumstances? Most airlines will have HEPA filters at the moment. The evidence is that HEPA filters do protect from COVID-19, the transmission of COVID-19 inside the aircraft. There are few aircraft that do not use HEPA filters as a matter of design, and the alternative they use is not as effective, in which case you might have a much stronger point and say, look, why didn't you follow that? Why didn't you follow them? And the other possibility is what happens if the crew reacts, how the crew reacts to a passenger that develops symptoms of COVID on board. Have they isolated him or her? Have they paid attention to him or her? There's case law to suggest that the crew's inaction or the crew's maltreatment of passengers in terms of medical emergencies do amount to an accident. So I don't think there's a clear yes or no. Whoever tells you is a clear yes or no answer, I think it's misguiding you. But I think it's very, very, very much a fact-based approach. And my view is that not many cases will come up successfully ones, but yes, let's see what happens. And on that thought, not a very positive thought, but a necessary thought these days, thank you very much.
Thank you, George. Thank you to the all speakers. I see that Andrew has just escaped so that he doesn't answer the questions, but I'm sure we'll catch up with him at one point. Before I go into the questions, and many questions are coming in, just wanted to remind you that the second leg of this is going to be next week, this time, where 4 of our other colleagues in the Institute of Shipping and Trade Law, as you know, we are probably one of the largest institutions specializing in this area. We'll look at other issues, mainly COVID, but going a bit beyond the COVID and talking about autonomous ships as well, which will be a second leg of this. So please keep in mind. And of course, it's a great opportunity when there's so many of you to remind you that actually the wishes of some of our followers been coming too, because our colloquium is quite popular and famous, but a lot of people complain that, well, we can't come to Swansea all the time. Well, you don't have to, because we have decided this year that due to the pandemic, we're going to actually run our 16th annual colloquium as an online event, and it's going to be focusing on disruptive technologies, climate change, and shipping law, 11th of September, and more information on this will be available soon. So, Andrew now is back, so it's a great opportunity for me to fit the questions. Thank you for the questions coming in. We'll try to take as many as we can in the next 10 minutes. But I suppose I start with Andrew, given that the first question about almost 35 minutes ago came to you, is essentially the distinction between force majeure and frustration. The question, as I understand it, is saying if parties are relying on force majeure clauses in the contract, do they have to bring the contract to an end? Or could this be a wait and see situation to see whether the event actually ceases so that the contractual obligations can be performed? Andrew?
The difference between force majeure and frustration. A force majeure clause, generally speaking, is much wider than frustration. And generally speaking, force majeure clauses don't bring the contract to an end. They merely excuse what would otherwise be the breach of an obligation. Because one of the problems with frustration is that it works on the way, in the way of bringing the contract to an end. Force majeure is a much more directed doctrine, which simply says if you are prevented from fulfilling a particular obligation by a matter beyond your control, then you're not liable. But very often that obligation may remain. So, for example, a force majeure clause may excuse late delivery, but the obligation to deliver does still remain. On the other hand, sometimes, of course, force majeure will, in practice, bring the contract to an end. If I am under a duty to deliver to you during the month of July, and force majeure prevents me for the whole of July delivering the goods, in that case, obviously, my obligation to deliver comes to an end. But generally speaking, force majeure is wider than frustration and tends to deal with obligations rather than the contract as a whole.
Thank you, Andrew. Simon, you're going to be busy next because there are a number of questions.
Okay, let me unmute myself. Am I?
Yes, you are, fine.
Oh, I'm on live. I have been unmuted. Okay,
Someone has already unmuted you.
Thank you.
The first question, which came a bit earlier, relates to seaworthiness, and that's from Carriage. You might see a lot of questions coming from Professor Sawyer. It's not actually me. I made a mistake this morning. I asked people to send a reminder and they send it with mine. So all the questions seem to be coming from me, but they're not from me, from the speakers. But this one comes from Darius. It's about medical stores. Can failure to carry medical stores, additional to the minimum mandated by the flag state, but prescribed by the port state for ships trading from and to its ports, render a ship unseaworthy?
I think the answer to that would be yes. But in the case of our COVID situation, I think it's rather academic because there's no medical supplies which can help you with COVID, apart from having a large quantities of paracetamol to help bring the fever down.
Thank you. Simon, we'll stay with you because there is a question which also I was thinking, this takes it to a different level. The question is, would a delay in granting the free pratique amount to vessel being not ready? Given that most of the free pratiques are actually granted by radio and notice of readiness is tendered upon arrival.
Well, it's not really it's not a mere formality, is it? I mean, I think you're going to get people presumably coming on board to come and inspect the crew, aren't you?
Yeah. But the one thing which we haven't actually looked into, and it's a bit confusing, as a person who looked into it a bit, I am certainly a bit confused, is whether free pratique or not clauses. Because there are a number of judgments where in passing the courts seem to suggest that actually they do not change the legal analysis at all. I am not personally sure about this, because if they actually do not change the legal analysis, what is the purpose of whether free pratique or not being added into a charter party? Do you have any views on that, Simon?
Well, there is the London arbitration number 11 of 2000, where that's exactly how the clause was construed. You've got 4 crew members don't have their vaccination certificates. That results in a delay, getting free pratique. You're not ready at that stage. But I think that what's the point of the clause? I agree. I think that it should mean what it says on the tin.
I think so. I personally think so. Thank you. Gizem has a question. Clearly, I feel that Gizem has a case ongoing, similar on this issue. If in a charter party, there is an obligation to discharge at an LNG port, an LNG port seems to be infected. If there is a clause in the charter party defining what is safe port by excluding infections and pandemics, shall the vessel approach to the port, or should the vessel approach to the port?
Well, if you are redefining with a clause like that, I think you would have the you would not be obliged to go there, because there's a pandemic there. I mean, yeah. I mean, you might choose to go there, but I don't.
I think if there is a definition or contractual definition of safe port, and if according to that definition it is not safe, then I don't see anybody being able to force you. Otherwise, no. As you say, it should do what it says on the tin. So I completely agree personally.
Yeah.
Thank you. I'm looking at other questions. As an owner, can I dispute charterers claiming force majeure if they sent the ship to a port which was under force majeure, but could have diverted the port to a different port? I'm a bit unclear about.
Well, you see, I'm always a little bit sort of my mind tends to go blank when I hear the word force majeure in the context of charter parties. I think, well, what type of clause have you actually got in mind? Even is it one of these catch-all things that no fault of the charterers or something? You don't tend to get force majeure clauses. I mean, but I'd like to see the wording of the clause. The actual specific clause which you've got in mind.
Well, Simon, you are very popular. I think that probably answers it very well. You are very popular. I have a question to Professor Bourne in relation to the off-hire clause under NYP 46 clause 15.
Yeah.
A ship has arrived at the berth for discharging the cargo, but the stewardess refuse to work on the ship because they are scared of contracting COVID-19. This has caused delay of 7 days. It's not very specific, this question at all. Can charterers argue that the vessel was off-hire on the basis that the actions or omissions of the stewardess takes them outside the ambit of their agency, i.e. a global Santosh kind of argument?
Well, I think we're looking at off-hire events for a start. We've not got deficiency of men. It's not deficiency of stevedores, so it's so we forget about that one. So we're looking at any other cause preventing the working of the vessel, and this is not something to do with the vessel or the crew. So I would say no. Possibly though, if you add the word whatsoever, any other cause whatsoever, then you've got a situation which is analogous to the Port Authority's unexpected actions and saying, oh, you can't sail now, you've got to get rid of these sweepings. So
but
it depends.
Would it be different, Simon, if this was not a FIOS type of situation and providing the stewardess was the obligation of the ship owner under that particular charter party? Optional, but
if it's the obligation of the well, if it's the obligation of the ship owner, then we might be looking at whether there's been
any other event similar to deficiency of the men kind of thing.
Yeah, I think what you would then be, you have an argument of deficiency of men type of thing, or an argument for breach of contract, because because your guys haven't been doing what they're meant to be doing.
I think so. I think so. I mean,
it's a bit of a difficult one, but yeah.
Yeah, but this is turning into a dialogue, I think, between you and me. There's another question. If the vessel is subject to quarantine restrictions on suspicion of COVID, I believe, which later proved to be not the case, can the time loss be claimed? I suppose we need to ask the question whether it's under a time charter party or not.
Yeah.
If it is under a time charter party and the vessel is quarantined on that basis because there was a suspicion of COVID, but later turned out to be not the case.
I would say it's not. If you've got any other cause, it's not off hire. If you've got any other cause whatsoever, then I think it's like the Laconian, the diction of the Laconian confidence. I think it would be off hire.
Andrew, do you have anything to add? Because I want to include the others as well into the discussion.
I don't think I do on that particular point.
Thank you.
Wasn't there a question, Barish, which I saw about letters of indemnity? Was there one in COVID?
Could it be in the chat, because I am looking at the questions.
I'll just have a look. I'll get that.
If it's a question and you want to take it, please do. Just to recoup.
Let's see. Oh gosh, there's been quite a lot of chat going on.
When you're finding it, George, is George with us?
Yes, I had a. Yeah.
You had a question about COVID contracted passenger. Can they sue airline for tort liability? I think I answered that. You answered that, but.
Yes, I think yes, I answered that. But even in the public domain, I think that if you apply Article 29 properly, the answer is no, because courts have said that anything that is related to carriage by air, any damages related to carriage by air, have to go through the Montreal Convention. So unless you prove that the cause of the damage was not related to the carriage by air, was somewhere in a warehouse before, you have to use the Montreal, which doesn't allow for tort actions outside of it. If that helps.
Thank you. Thank you. Simon, I found your letter of indemnity question.
Yes. This is
somewhere. You find it as well?
I found it. So this is the situation where the physical bill of lading can't get through due to coronavirus, but there's prima facie evidence that the consignee is the same in the photo. Well, I think there are two things here. First of all, the letter of indemnity is a separate thing to your position under the bill of lading, and there's no the letter of indemnity will protect you in the same way letters of indemnity protect you in any case, but it's not going to stop somebody suing you for misdelivery if you end up actually doing a misdelivery. The fact that the physical bill of lading can't get through to, well, if it's the problem of the physical bill of lading not getting through, and the consignee is the same and he's got a photo, well, has it actually ended up going to the wrong person? Is there actually a misdelivery claim there? And I would think probably not. I mean, that's just going to be it'd be nominal damages, but you've actually delivered to the right person. If you've delivered to the wrong person, I don't think you've got any defense.
Yeah. I think one, we always like to get a feedback as well, and this is a live feedback. What I gather from this discussion, Simon, is that I think you're going to be very busy in July writing a number of IISTL blogs, because there are so many issues
yes.
that have to arrive on this.
That's right.
There is another question, which again goes to you, I believe. And I seem to losing it. Apologies. It was about the safe port. Yes, it was Jose's question. In the context of a time charter party, you have concerns that a particular port is not healthy, safe. How can I prove this? What I need to do, in other words, from ship owner's perspective, to prove that? Am I under an obligation to trust local authorities and information provided by them? I suppose Jose is asking this question because they are facing this kind of disputes regularly nowadays with the unsafe port issue. So, Simon, anything you can say about that?
I think you probably do have to trust the local authorities, and you have to trust your own safety precautions based on the general advice, which is, I mean, presumably the problem is going to be about interactions between crew and shore workers during the loading or discharging of the vessel. And if you've got shore workers all sort of garbed up like spacemen, you're probably going to be okay. But that is really quite difficult. But I think you probably do have to trust the local authorities.
I believe there is no other option, really.
And just keep washing your hands with soap. The best thing out. I've worn out several blocks during the pandemic.
George, there is a question to you. I believe it's about this passenger. If it can be proven that you contracted COVID from a passenger who was refusing or hiding the fact that he was infected or she was infected, could there be an issue of tort liability against that person?
It could be a question of tort liability against that person. The airline certainly would defend it on the basis that is it an unusual, unexpected, to expect a fellow passenger to die if he or she knows to disclose the information, and what can I do to get over it, to persuade passengers to disclose information pre-flight. But I think from the point of view of a passenger to a passenger, so yes, it could be a tort liability. And then the question would be that I think that claim could fall under the Montreal Convention on the basis that the Montreal deals only with the relationship between the airline and the passenger and not inter-passenger relationships. So that could be, I believe, yeah, could go outside, could be filed and could go outside the scope of Montreal and the local law, whatever that local law would be.
Well, thank you very much. Panelists, is there anything you want to add? Because I am actually very, very encouraged that more than 140 people actually still with us, even though we go on about 10 minutes over the scheduled time. Is there anything you would like to add, Andrew, Simon, George, before we bring it to an end?
Thank you very much for the very interesting and difficult questions. Glad you've been paying attention.
Andrew?
I'd say exactly the same, and I'd also add I agree with George that I see no reason whatever why one airline passenger shouldn't owe a duty of care to another one, not to give them not to give them COVID.
Similar cases have been done with transmission of HIV, I believe.
Yes.
George, I think that also highlights that you probably need to do something for the block on this particular.
Yes, I could feel it coming.
And, you know, part of my job is to moderate, but also bring to your attention what we've got. If you like, please follow us on our Twitter account, but also on our blog, which is much more academic. And we try to share our views. It's very contemporary. Actually, the decision was delivered yesterday, and I think by lunchtime, Professor Kettenborn had managed to put a comment yesterday onto the IISTL blog on terminal operators' limitation of liability, right, and so on and so forth. So I think this is where we bring it to an end. And we would like to thank everybody who actually gave their time to be with us this lunchtime. Thank you very much. I think at one point we had close to 200 participants, which is a great number to have. even though more than that enrolled, but I believe life sometimes gets in between things. So thank you very much. And please, next week, this time, we would like to see you again with a different set of issues, but certainly no less exciting than this one. Thank you very much. And I would like to
Thank you.
Thank you.
Bye.
Thank you.